from Tamil Nadu, where the real action is taking place now. The governor was in news. By the way, very good governor. He was governor of Bihar. Had a liking for me. So, as the chancellor, whenever he will hold the meeting of a senate, he will force the vice chancellor to start it with my lecture. Number of universities senate meeting in Bihar started with my lecture. But of course, governors behave on dictate of center. Last year, we got a judgment from the court. There were some 10-11 bills which were passed by the Tamil Nadu Assembly, not signed by the governor for 2 years, for 3.5 years, for 4 years. Then there was a similar case from Punjab, and Supreme Court said governor cannot like this sleep over the bills, and all these bills were therefore sent back by the governor to the assembly for reconsideration. The law is very clear that when a bill is presented to the governor, having been passed by the assembly, either he has to sign it, or he has to return it, or refer it to the president. 3 options. Governor returned them. All of them were passed again without any change. The law after 42nd Amendment is that if a bill or advice by the ministry is reiterated after reconsideration, the governor or the president is bound. Of course, president does not have this option that he refers to somebody else. Governor has this option to refer it to the president. Therefore, Justice Pardiwala said, nothing doing. We will now deem all these bills which have been passed as assented to, and they became law because of the judgment of the Supreme Court without the assent of the governor. Ideally, the judgment of the court should be followed. What was the Shah Bano controversy? Many say, I don't know how far Aman will agree with this or not, that one of the reasons of the rise of BJP is because of the Muslim protests against Shah Bano, that we will not accept the judgment of the Supreme Court. It was post this judgment that BJP started saying we will not accept the Babri Masjid judgment, because at that time they at least had this thing in mind that we will not win this case. आस्था के मामले में किसी न्यायालय को बोलने का हक नहीं है, क्योंकि आपने पहले कहा इट इज एन इंटरफेरेंस इन आवर शरीयत, तो उन्होंने कहा हम आस्था क्यों. And therefore, when you got the law overturning a judgment of the court, Supreme Court, they also had to get a deal. And they say in this deal, Rajiv Gandhi got the doors of Babri Masjid, which was locked, open. This how is the explanation given by many people, including Arif Muhammad Khan. Though, by the way, it is in terms of chronology, quote unquote, wrong. Chronologically speaking, there was breaking the lock movement which was picking up, and they said before Shivratri a decision is to be made, we will break the lock. And the locks were finally opened on 1st February 1986. This law overturning Shabano judgment will be passed in May. It was introduced in March but passed in May. But probably some agreement, some kind of agreement took place that we will introduce this law. We will exempt you from paying maintenance. At that time, the law was that the maximum maintenance under 125 will be 500 rupees. Because of Muslim stupidity, now there is no limit. And interestingly, the text of the law which was passed was provided by the Personal Law Board and other Muslim intellectuals of the time. And the law provided that if there is a divorce, the maintenance shall be payable within iddat period. They thought that it will be good enough. We will be paying maintenance only for 3 months, 10 days of iddat period. While if a Hindu gives a divorce or a Christian gives a divorce, he has to pay the maintenance for the whole life of divorcee or till she remarries somebody or is found involved in adultery, etc., etc., or some amount due to her under customary law on divorce has been paid. The argument of Muhammad Ahmad, who was himself a lawyer, and Shah Banu was his cousin. The other wife was also the cousin. They were living happily for 2 years or many years. Then for 2 years she was living in a separate house. I met Shah Banu's son many years ago, who practices in Delhi. The liability which was fixed was only of about 179 rupees. The earning of the man was about good 25,000, 20,000. He was a reasonably good lawyer. But it became a whole ummah issue, so to say. One, the judgment of Shah Banu by Chandrachud was correct. The plea was that we have given meher, which is an amount due on divorce under the customary law, and therefore the exception of 127 is applicable. Chandrachud said, meher has nothing to do with divorce, and this is what the correct Islamic position is. Meher is consideration to be paid to wife as a mark of respect at the time of marriage. You are in default that you are not paying it. You should have paid it on that day itself. It has nothing to do with divorce. And therefore, the amount which 127 anticipates is a different amount. It's a different story that prior to Chandrachud's Shah Banu judgment, a very liberal judge, Krishna Iyer in Tahira B and Fazlan B, had said that meher is that amount, but if amount is not reasonable, we will enhance the amount. But if you pay that, you are exempt from liability. Chandrachud said, no, meher has nothing to do with divorce.